All right, I'm back with David Azizi from the law offices of David Azizi, and a very interesting topic often comes up as it relates to car accidents. And if a driver has passed out before the accident actually happens. And it may be a little bit interesting. David, explain exactly why this is different than if the driver is fully functional.
Well, it's a little bit different because the way the law is set up is that if an act of God is involved, for example, let's say somebody with a good medical background for no unknown reason, all of a sudden he gets a heart attack in the middle of driving, the law says, well, that's an act of God. It's nobody's negligence. The driver of the vehicle would not have any notice or knowledge of the fact that they're going to have this sudden heart attack. None of his doctors or medical personnel would have had any information that this guy would have a heart attack to forbid him or tell the DMV that this guy should not drive. So in those scenarios where it's some kind of a sudden act of God, and in a sense they call it act of God because it's a natural cause that causes you to pass out or be incapacitated and you cause an accident, the law says, well, look, nobody's negligent, because under the law you have to establish that somebody was negligent, they had a duty, there was a breach of that duty, and as a result of that breach of that duty, you sustain damages, and now you're entitled to recover for those damages. Now, in the flip side of it, like I said, let's say somebody goes to the hospital, and the doctor should have at least stated to this guy that, look, based on your medical condition, we don't advise that you drive. It's up to you. You could say, they can't keep you as a hostage, but as long as you sign off or say I don't care, or they at least notate in their medical records that they advise you not to do so, and you left, well, again, the hospital is not responsible. But in some cases, the hospital doctor may be negligent, and he or she should have told this guy, don't drive, and they failed to do so. The guy gets behind the wheel and causes an accident. There are cases where, for example, minors who are by law not supposed to be provided any alcohol. They go to some party, they drink too much, and the owner of the party just lets them out, and an adult person provides that type of alcohol. The minor gets out, just passes out from being too drunk, causes an accident. Well, even though they passed out, there's liability there. There's other circumstances, for example, where somebody has a seizure disorder, and the doctors know that this person is not somebody fit to drive, and they don't notify the DMV or notify the authorities or somebody like that. That doctor could potentially be responsible because they had an opportunity or requirement by law to report that, and they failed to do so, and as a result, this person passed out and caused an accident. So really, the answer is a yes and no. It depends on the circumstances. The best thing to do is always consult an attorney, such as myself, where we can look into the matter and determine as to whether this guy was fit to drive or not, and if he wasn't, did anybody know about it, and whether they did something about it or not, and that would be your basis to recover.
Absolutely, and as David said, it would be best to contact a personal injury lawyer that has experience. Please feel free to contact the law offices of David Azizi. The phone number will be in the video as well as in the information below. Thank you for your time, David.
All right, thank you.